Good afternoon, ladies and gentlemen. The afternoon section shall commence soon, so please be seated. A gentle reminder, please kindly switch your mobile phones or any electronic devices to silent mode. Once again, the Congress will be conducted in English and Cantonese with separate channels for simultaneous interpretation in Cantonese, 普通话 and English. Please tune to Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for 普通话. You may pick up your headsets, SI headsets at the entrance of this room. If you wish to have a SI headset, please raise your hand and our event team will pass one to you. For online participants, you may choose your preferred language as shown on the screen by clicking the channel directly. You're recommended to use headphones for better sound experience. Ladies and gentlemen, our afternoon section will commence now, so please be seated. Thank you. Ladies and gentlemen, good afternoon. Welcome back to the afternoon section of the Rule of Law Congress, Rule of Law and Justice for All. On stage, we're now having our second panel section of today, titled Access to Justice for All, Diversified Dispute Resolution Mechanism. And we're so delighted to have the following moderator and speakers moderating the section. First, let me introduce our moderator, Mr. Victor Dawes. A big round of applause to welcome Mr. Dawes. Mr. Dawes is the chairman of the Hong Kong Bar Association. And joining us on stage, we have three distinguished speakers. They are the Honorable Mr. Justice Tang, Mr. Rimsky-Yuen, and also Ms. Winnie Tam. Welcome our speakers. Before I pass the stage and time to our moderator, Mr. Dawes, just a gentle reminder to all of you, if you have any questions for our speakers and moderator, remember to pass your question to our moderator and our team by filling the question paper provided to you earlier. Or you can simply scan the QR code that is now shown on screen and type your questions into our Q&A system directly. For online participants, you can simply type your questions in the chat box at the bottom of the screen. Without further ado, our speakers are now ready, so I would like to pass the time and stage to our moderator. Mr. Dawes, over to you.
I want to welcome everyone to the second panel session of today. The title is Access to Justice for All, Diversified Dispute Resolution Mechanism. And I'm thrilled to be joined by a very distinguished panel. I'm sure most of you are actually familiar with our speakers today, and you'll forgive me for keeping the introduction to relatively short. In the order of presentation, can I first of all introduce Mr. Rimsky-Yuen, SC. As most of you know, he's the chair of the Hong Kong Mediation and Accreditation Association. He is also the co-chairperson of the HAIAC, a practicing senior counsel, arbitrator, and mediator. And a lot of you will remember Rimsky as our former Secretary for Justice from 2012 to 2018. The second speaker is Mr. Justice Robert Tang, currently a non-permanent judge of our Court of Final Appeal and one of the most popular arbitrators in our jurisdiction. A lot of you in this room, in fact, looking around, I think most of you are practicing lawyers in this jurisdiction, and I'm sure most of you would have read and have cited Robert's judgment in your practice. Robert was a member of the Hong Kong Bar since 1970. He was appointed Queen's Counsel in 1986. He joined the bench in 2004 as a judge of the Court of First Instance and was promoted to the Court of Appeal in the following year. He joined the Court of Final Appeal in 2012 and retired as a full-time judge in 2018. Now, last but not least, of course, we have the rows between the phones. Ms. Winnie Tam, SC, Winnie is also a practicing senior counsel, and in addition to being our top intellectual property specialist, Winnie is a recorder of the High Court. She sits as an arbitrator in a wide range of commercial cases. And then on top of all that and outside the law, Winnie is also the chairperson of the Hong Kong Palace Museum Board, and she also chairs the Communication Authority. We can all ask her later where does she find time for all that. Finally, it gives me great pleasure also in that all three of them were my predecessor, and they were all chairmen of the Hong Kong Bar Association. They left very big shoes for myself to fill. Returning to the topic today, access to justice. Provision of affordable and effective and timely legal and dispute resolution service is certainly an important component when we consider the rule of law. As an international dispute resolution hub and an IFC, Hong Kong has really got a diverse dispute resolution mechanism catering for the needs of our citizens and also our friends from abroad. In fact, I was inspired by Professor Tirado when we spoke about food in Hong Kong the other night when we were at the Legal Week races. But I was just reminded by Secretary for Justice that he actually used the same analogy this morning. So at the risk of being accused of plagiarism, I will stick to my point. What we talked about was how he loved eating in Hong Kong, and that there's really something for everyone, from Michelin star cuisine to the authentic hawker stores you can find around town offering cheap and tasty food. There's really something for everyone. And like the Secretary of Justice, I do think we can say the same thing about dispute resolution services here. No matter whether you have a high-value arbitration or litigation, or just a small dispute between neighbors, you'll be able to find something that would ensure that your dispute is resolved in an economic and proportionate manner. So on that note, and without further ado, I will first invite Rimsky, who will give us an overview on the different options in Hong Kong. Thank you very much, Rimsky.
Secretary of Justice, distinguished guests, ladies and gentlemen, good afternoon. First of all, may I express my gratitude to the Department of Justice for giving me this opportunity to share with you some of my personal thoughts on the topic chosen for this session, namely, access to justice for all, diversified dispute resolution mechanism. As the first panelist, I intend to give you a snapshot of the situation in Hong Kong. The other two panelists, Robert and Winnie, will focus on individual areas relevant to the topic in question. It has been generally accepted that the rule of law in Hong Kong is a cornerstone of Hong Kong's success, especially in respect of her role as an international city and in particular as an international financial center. Today, of course, is not the occasion to embark upon a detailed jurisprudential discussions of the concept of the rule of law. However, for present purposes, one point is sure. Access to justice and dispute resolution are two of the important and interrelated elements of the overall concept of the rule of law. Put shortly, even the best legal and judicial system would become meaningless if legal disputes cannot be resolved fairly and effectively, or that parties who believe their legal rights have been infringed cannot have access to an effective dispute resolution regime in one way or another to satisfactorily enforce their legal rights. In the well-known text of the rule of law by Lord Bingham, the learned judge explained this concept as follows, and if I may quote, "It would seem to be an obvious implication of the principle that everyone is bound by and entitled to the protection of the law, that people should be able, in the last resort, to go to court to have their civil rights and claims determined. An unenforceable right or claim is a thing of little value to anyone." End of quote. In Hong Kong, the right to access to justice is constitutionally guaranteed under Article 35 of our Basic Law, which reads as follows: "Hong Kong residents shall have the right to confidential legal advice, access to the court, choice of lawyers for timely protection of their lawful rights and interests, or for representation in the courts and to judicial remedies. Hong Kong residents shall have the right to institute legal proceedings in the courts against the acts of the executive authorities and their personnel." Article 39 of our Basic Law also provides, among others, that the provisions of the International Covenant on Civil and Political Rights as applied to Hong Kong shall remain in force and shall be implemented through the laws of Hong Kong. In this regard, Articles 10 and 11 of the Hong Kong Bills of Rights, which deal with equality before courts and right to fair and public hearing, as well as right of persons charged with or convicted of criminal offence respectively, which are set out in Part 2 of the Hong Kong Bills of Rights Ordinance, are also important provisions in the context of access to justice. In addition, access to justice is protected under common law. Indeed, the common law right of access to court has often been described as a constitutional right. Among others, such right is reflected in the well-established common law presumption of legislative intent that access to the court in respect of justiciable issues is not to be denied save by clear language. Besides, the ability of an individual to bring prosecution is another facet of this right of access to court. Nevertheless, access to justice is not and should not be confined to access to courts, which resolve civil disputes through conventional court litigation. An effective dispute resolution system, other than that of the court, is equally important. Indeed, as early as April 1976, Professor Frank Zender of Harvard Law School started to articulate the concept of multi-door courthouse in a conference concerning the administration of justice. Looking at matters as they now stand, I would venture to suggest that Hong Kong's dispute resolution landscape offers a modified and enhanced version of Professor Zender's idea of multi-door courthouse. The key reasons, if I may venture to suggest, include, first of all, the judicial system of Hong Kong is there to act as the ultimate gatekeeper of dispute resolution, and thus also the ultimate gatekeeper of justice. Second, in addition to court litigation, there are various other means of dispute resolution available for the parties to choose. Key examples include arbitration, mediation, and adjudication. Third, the question of cause is one of the key considerations in dispute resolution. The system of legal aid in Hong Kong and also the recent development concerning the funding of arbitration and mediation in Hong Kong are effective means to uphold the concept of equality before the law as well as to ensure access to justice. For present purposes, I would briefly deal with these three aspects. Starting, if I may, with the court system. Article 19 of our Basic Law stipulates that the Hong Kong SAR shall be vested with independent judicial power, including that of final adjudication. It goes on to provide that the courts of the Hong Kong SAR shall have jurisdiction over all cases in the region, except that the restrictions on their jurisdictions imposed by the legal system and principles previously enforced in Hong Kong shall be maintained. Section 4 of the Basic Law specifically deals with the judiciary. A few of the provisions contained in Section 4 merit attention. Article 80 stipulates that the courts of the Hong Kong SAR at all levels shall be the judiciary of the region, exercising the judicial power of the region. Closely related to this is Article 85, which provides that the courts of the Hong Kong SAR shall exercise judicial power independently, free from any interference. Another provision of importance in the Basic Law is Article 82, which stipulates that power of final adjudication shall be vested in the Court of Final Appeal, which may, as required, invite judges from other common law jurisdiction on the Court of Final Appeal. In recent years, the arrangement under Article 82 concerning overseas non-permanent judges of the Court of Final Appeal has attracted certain discussions. Some discussions go beyond the Court of Final Appeal and touches on nationality of our judges. Since Article 90 of the Basic Law only imposes nationality restrictions on the Chief Justice of the Court of Final Appeal and the Chief Judge of the High Court. Healthy discussions on topics of public importance is a reflection of, and indeed, the aim of any democratic and open society. Constructive discussions can bring about desirable changes which can make our society a progressive one. However, in discussing matters concerning the judiciary, especially those that are governed by the solemn provisions of the Basic Law, one should perhaps bear in mind that those relevant provisions in the Basic Law represent the result of serious and lengthy discussions during the drafting of the Basic Law. They were included in the Basic Law for good reasons. In particular, the participation of overseas judges in our Court of Final Appeal has been viewed positively by the international business community. It also helps to ensure the continuous presence of international expertise of the highest caliber, as well as the facilitation of cross-fertilization in the development of Hong Kong's common law. One international trend that may be worth mentioning in this regard is the growing popularity of international commercial courts in different jurisdictions. In some of these international commercial courts, such as the one in Singapore, a similar formula is adopted in that foreign judges are invited to sit in their international commercial court. With the constitutional safeguard and the professionalism of our judges, court litigation continues to be an effective means of access to justice in Hong Kong. Moving on, if I may, to other forms of dispute resolution. Arbitration is, of course, one of the most natural options that springs to one's mind. Unlike court litigation, the mandate of the arbitral tribunal is derived from the parties' arbitration agreement. The concept of party autonomy is one of the key pillars of arbitration. Freedom of choice over arbitrators and also procedure, confidentiality, and ease of enforcement of arbitral awards pursuant to the New York Convention are the key factors which explain the popularity of international arbitration. They are also the reasons why international arbitration provides a robust alternative to court litigation in terms of access to justice. The development and promotion of arbitration in Hong Kong has a long history. Since the setting up of the Hong Kong International Arbitration Center in the 1980s, arbitration whether domestic or especially international, has gathered momentum in Hong Kong. Arbitration is not conducted in a vacuum. Supporting legislation is of paramount importance. That's why the Department of Justice continuously keeps a close eye on the development in the arbitration landscape and has introduced significant changes to the arbitration ordinance in the past 2 decades so as to ensure that the arbitration legislation in Hong Kong can meet the needs of our end users. Further, there is the support of the arbitration-friendly judiciary. Against such background, coupled with the hard work of the arbitration community in Hong Kong, arbitration has provided an effective means of access to justice, especially in the commercial context, which is another pillar which supports Hong Kong's status as an international financial center. Let me move on to mediation. In the 2014 mediation conference held by the Department of Justice, our then Chief Justice, that is the Honorable Chief Justice Geoffrey Ma, described mediation as follows. He said this: "I have had debates with fellow judges over whether mediation, like arbitration, can be said to be a part of the administration of justice. This is largely a sterile debate over whether the term the administration of justice is confined to what the courts do and the role of judges. For me, the administration of justice includes, as an integral activity, the resolution of disputes to arrive at a just, proper, and legally justifiable result. Mediation fits into this rubric." End of quote. Indeed, with the introduction of the mediation ordinance in Hong Kong and the subsequent apology legislation, together with the support of various mediation organizations and the dispute resolution community, the mediation landscape in Hong Kong has undergone fundamental changes in the past decade or so. In short, mediation is now another additional means of access to justice. Despite the absence of a top-down adjudication or ruling, the outcome of mediation in the form of an amicable settlement is often more receptive to the parties, as mediation can often achieve objectives that court litigation cannot. In the context of access to justice, another pertinent example perhaps is the security of payment in the construction context. The security of payment rules came into effect on the 23rd of February 2022. Cash flow has been described as the lifeblood of construction industry. The security of payment rules seeks to avoid blockage of payment or delay of payment as a result of disputes, which are not uncommon in the construction industry. The Hong Kong International Arbitration Centre has since established the panel of adjudicators for the security of payment scheme and also a new set of rules so as to assist the implementation of these schemes. On the whole, there are different means of dispute resolution other than the conventional court litigation. These different means have their respective attractions. There is no one-size-fits-all solution in the context of dispute resolution. Just like our moderator Victor has mentioned, what is important is that the parties have the choice in front of them when they face disputes, just like when they face choice of restaurants, and can pick the option most suitable to the disputes they face after obtaining appropriate advices. That should be one of the ultimate aims of access to justice. Lastly, I wish to say a few words about funding of dispute resolution. Resolving legal dispute is often expensive. In the past, the court of a certain jurisdiction has been compared with the Ritz Hotel, with the connotation that unless you are rich, don't come in. In Hong Kong, various types of court litigation, such as matrimonial disputes, personal injury and fatal accidents litigation, are funded by legal aid. Compared with many other common law jurisdictions, the legal aid regime in Hong Kong is one of the most comprehensive regimes in the world. Besides, legal aid is not confined to court litigation. In appropriate cases, mediation is also covered. The funding of arbitration in Hong Kong has also undergone considerable changes. With the passing of the Arbitration and Mediation Legislation (Third-Party Funding) Amendment Ordinance 2017, and also the recent Arbitration and Legal Practitioner Legislation Outcome-Related Fee Structures for Arbitration Amendment Ordinance 2022, end users of arbitration and mediation can expect more flexibility in reaching a fee agreement with their legal teams. With such flexibility, access to justice is accordingly enhanced as well. To conclude, the choice of different means of dispute resolution, coupled with the funding assistance or facilitation in one form or another, are essential to maintain and consolidate access to justice. In Hong Kong, under the one country, two system, our legal and judiciary systems remain robust, and our dispute resolution landscape covering arbitration, mediation, and others continue to flourish. It remains for me to thank the organizer again for this opportunity and to wish all of you an enjoyable day. Thank you.
I want to thank Rimsky for the excellent overview on the different type of dispute resolution mechanism. Not only has he reminded us of the important constitutional safeguards under the Basic Law, covering topical issues such as our non-permanent judges in the Court of Final Appeal, he also gave us an overview of the hot topics, if I can use that term, insofar as mediation and arbitrations are concerned. So thank you very much, Rimsky. Without further ado, can I now hear from our next speaker, Mr. Justice Robert Tang, who will tell us a bit about how Hong Kong as a cosmopolitan, the role that we can play in the process. Thank you, Robert.
Secretary for Justice, distinguished guests, ladies and gentlemen. In President Xi Jinping's speech on the 25th anniversary of the establishment of the Hong Kong SAR, he called Hong Kong a cosmopolis. He said, as a cosmopolis, Hong Kong's vitality has impressed the world. In the original Chinese, he said, 香港作為國際大都會，勃勃生機，世界為之讚嘆. His description of Hong Kong as a cosmopolis is significant. According to the Collins English Dictionary, a cosmopolis is an internationally important city inhabited by many different peoples, reflecting a great variety of cultures, attitudes, etc. I believe this accurately describes Hong Kong and explains much of Hong Kong's success. Importantly, implicit in the description is the acceptance of and respect for different cultures, attitudes, etc., without which no city could truly be a cosmopolis. Elsewhere in his speech, President Xi talked about Hong Kong's status as an international financial, shipping, and trading center. And he said, quote, "The central government fully supports Hong Kong in its effort to maintain its distinctive status and edges, to improve its presence as an international financial, shipping, and trading center, to keep its business environment free, open, and regulated, and to maintain the common law so as to expand and facilitate its exchanges with the world," unquote. The rule of law is the foundation of Hong Kong. The policy of one country, two systems not only entrenched the rule of law, it was designed with Hong Kong as a cosmopolis in mind, as the following provisions in the Basic Law amply demonstrate. First, Article 24, paragraphs 4 and 5, which provide that, quote, "Persons not of Chinese nationality who have entered Hong Kong with valid travel documents have ordinarily resided in Hong Kong for a continuous period of not less than 7 years and have taken Hong Kong as their place of permanent residence before and after the establishment of the HKSAR," unquote, "and their children under the age of 18 or under the age of 21 also have the right of vote in Hong Kong." So long-term non-Chinese nationals who have taken Hong Kong as their home may become a Hong Kong resident with equal rights. Apart from a few positions, for example, that of the Chief Executive, the Chief Justice, the President of the Legislative Council, non-Chinese nationals can occupy important public positions. Few places in the world treat non-nationals so generously. Of course, unless non-nationals can feel at home here, they are unlikely to want to make Hong Kong their home. To make them feel at home and make Hong Kong their home, their different cultures, attitudes, etc., must be accepted and respected. I think Hong Kong has succeeded in that. We have a large number of non-Chinese nationals in Hong Kong who have made their homes here. According to statistics available to me, there are about 85,000 US nationals in Hong Kong as of 2018, and over 33,000 UK nationals in Hong Kong, of whom 19,000 odd are of European ethnicity, almost 7,000 Chinese, etc. As of 2014, approximately 300,000 Canadian citizens of all ethnic backgrounds live in Hong Kong. Many of these, I believe, were Hong Kong residents who had emigrated to Canada prior to 1997. The French consulate estimated that there are about 25,000 French citizens in Hong Kong. I do not have the figures, but the number of Hong Kong SAR's residents who have been educated outside of Hong Kong must be very large. There are also mainland residents in Hong Kong, many of whom have been educated overseas. Many of these people are in Hong Kong working for important local, mainland, or international businesses, without which Hong Kong would not be an international, commercial, financial, and trading center. These people also reflect the great variety of cultures and attitudes, etc., which are characteristic of a truly international city. It is this international mix which has given Hong Kong its strength. Secondly, Article 9 provides, in addition to the Chinese language, English may be used as an official language by the executive authorities, legislature, and judiciary of the Hong Kong SAR. Because of Article 9, all legislations in Hong Kong are enacted in both Chinese and English, and both versions are equally authentic. English has remained the dominant language in commerce, finance, and the law after 1997. Thirdly, Article 8, under which common law continues to be used in Hong Kong. These provisions are essential to Hong Kong's success. So too is an internationally accepted mechanism for dispute resolution. In any dispute, parties want an impartial, fair, and expert tribunal whose awards will be enforced expeditiously, fairly, and impartially. For this purpose, one needs experienced arbitrators and a strong legal profession. The importance of international arbitration to Hong Kong is obvious. That is why, as early as 1985, the Hong Kong International Arbitration Center, HKIAC, was established. I've been associated with it from its inception, and I hope I'll be forgiven if I do not mention the other arbitral bodies in Hong Kong. It was recognized from the beginning that although the Hong Kong government would provide HKIAC with the necessary seed money and its premises at a nominal rent, HKIAC would be totally independent. HKIAC has always been independent of government control. It is also truly international. It is there not to serve Hong Kong only or any sectorial interest. From its inception, HKIAC has been international with an international secretariat. Today, members of the secretariat come from different jurisdictions and speak, I'm told, 10 different languages. They are recruited on merit, regardless of their nationality. HKIAC's affairs are under the oversight of its council. There are currently 27 council members who come from 15 different countries or geographic areas. They hold passports of the United States, Hong Kong SAR, mainland China, the United Kingdom, France, Sweden, Germany, Singapore, New Zealand, Israel, Colombia, Australia, India, Korea, and Russia. It is truly international in its makeup. The current co-chairs are an ethnic Chinese HKSAR resident, Mr. Rimsky-Yun, and a non-ethnic Chinese US citizen. There are also over 550 persons on HKIAC's panel of arbitrators and over 360 in its list of arbitrators. They hold different passports and are admitted to practice in a variety of jurisdictions, and they practice in many different geographical areas. In arbitrations administered by HKIAC, parties are most often represented by local and international firms. However, it is important to note that subject to the parties' agreement, the practice of arbitration, whether as arbitrator or as representative or advocate, is not confined to lawyers and does not require any formal qualification. Be that as it may, an international arbitration center requires a world-class, experienced, and independent legal profession. The Hong Kong SAR is well placed to handle international arbitration. There are over 12,000 solicitors in active practice or working in-house. They are made up of different nationalities. There are over 900 local law firms and over 80 foreign law firms in Hong Kong. Do not be misled by the word local. These local firms include many leading international firms from different common law countries, most noticeably from England and the United States. The foreign law firms, and there are about 1,400 registered foreign lawyers, are firms of foreign lawyers who offer services to the public as a practitioner of foreign law, and they include lawyers from many different jurisdictions. Hong Kong has also a very strong bar. There are over 1,600 barristers and over 100 senior barristers, senior counsel. The indigenous legal profession is independent and strong. They are well-trained and have honed their skill thanks to fierce international competition. Hong Kong is, together with London and Singapore, one of the most successful arbitration centers in the world. It is no coincidence that they have in common the common law system and English as the language of their law, as well as a world-class legal profession. But is Hong Kong slipping? I do not think we need to worry, provided Hong Kong can remain a cosmopolis. Indeed, there are signs that Hong Kong is recovering. For example, the figures up to October 2022 from the HKIC shows that the number of international arbitration in 2022 has far exceeded the figures for the same period in previous years. The Chief Executive has, in his policy speech, outlined measures designed to attract talents to Hong Kong. Hong Kong is indeed open for business. But these talents will want more than a good pay package. Hong Kong has to accept and respect the great variety of cultures and attitudes, etc., not only of the talents whom we wish to attract, but also to retain the many who are already here. If Hong Kong can remain a cosmopolis, I am confident that Hong Kong will continue to be a leading international arbitration center. Thank you.
Thank you very much, Robert. I'm sure the audience would like to join me in thanking you for reminding us the international nature of this jurisdiction. Of course, the place is only as good as its people. And looking at this crowd and looking at the guests that who joined us for lunch today, I think the international nature of this city has been demonstrated vividly. So thank you again, Robert. Now, last but not least, of course, Winnie will tell us a bit more about recent issues or topics in international arbitration and share with us some of her experience in sitting as an arbitrator and as advocate in arbitration.
Secretary for Justice, distinguished guests, fellow panelists, ladies and gentlemen, thank you very much for the Department of Justice for giving me this opportunity to join the Legal Week again and to share some of my thoughts. My talk today, I've actually prepared a few slides, but the slides are not terribly important. It is just intended to give a kind of outline. I have several points to make, and they are divided into three areas. First, the first point is perhaps already covered by other panelists. It is about the rise in popularity of arbitration for commercial disputes. The second point I would like to highlight is posed in the form of a question, and that is, does commercial arbitration promote access to justice, which is the theme, diversity, in this afternoon's panel. The third point I would like to cover is how do we prepare for a better future? Diversity and inclusion in arbitration. And in that, I would like to cover 3 points, and that is diversity in the mode of dispute resolution. Secondly, diversity in arbitral panels, and diversity in fee structure, which is, again, a point which other panelists have touched on. The rise in popularity of international commercial arbitration is evidenced by rising numbers in every set of statistics that are published. Now, it is quite remarkable that in the past years, we have been following this Queen Mary College and White and Case international survey on arbitration. And of the 2021 figures that we have seen, 90% of respondents to the survey prefer arbitration to litigation, either as a standalone dispute resolution procedure or in conjunction with other alternative dispute resolution methods. And these other methods would include mediation and adjudication, as Rimsky has already averted to. This would be the highest proportion ever reached, I would say, and it would still be on the rise, I predict. And most remarkably, out of the top 3 most preferred centers of arbitration, 2 are in Asia. As I see it, it reflects the rise of Asia as economic forces in the world, and it also reflects the rise of Asian cities in terms of their companies being involved in international commercial activities, transactions, and hence disputes. Now, what does arbitration have to offer that is so attractive in commercial dispute resolution that 90% of people think that they would prefer international arbitration? Well, some of my fellow panelists have mentioned party autonomy. Party autonomy is, of course, the most attractive aspect because the parties who want their disputes resolved where they have a prior existing commercial relationship would like some control over the process. And often litigants in court proceedings do not find that they have a lot of control. Number one is that the judge's diary is not in your control. Recently, I've had a lengthy trial which was scheduled only to happen in the next month, and that is December, vacated altogether because the judge has been given other duties. That is unsatisfactory. I'm not blaming the judiciary for it because sometimes judges do get appointed to other roles which are important and which the rest of Hong Kong may have to pay a little price for. But that is what I refer to as a lack of control and hence increasing the lack of certainty in litigation. Next is to some degree of control over how many and who to appoint as the arbitral panel, and that is equivalent to the judge sitting as the adjudicator of the dispute. Now, of course, in a three-person panel, the party gets to choose his side of a designation of an arbitrator, and then the opponent gets to choose his designation of an arbitrator. And then the chair of the panel would sometimes be either chosen by the institution, the arbitral institution, or by the 2 designated co-arbitrators. In the case of a one-person panel, the arbitrator would be chosen by the institution very often, unless the disputing parties are able to agree. Now that, nevertheless, still offers some degree of control over how you would like the arbitral tribunal to be constituted, because the parties who are in the commercial transaction can very well agree in advance as to whether they want a 3-person panel or a sole arbitrator, or even in some commercial contracts I have seen, they've even agreed who to appoint in case they go into a dispute. Now this mode of the parties having put their minds to what will happen and what they want to happen, where before any dispute arises, is actually conducive to a smoother and easier resolution of disputes, hopefully, some of the times. Whereas parties in litigation are often engaged in more acrimonious exchanges and are more adversarial in nature. Next is the flexibility in procedure. That is often cited as another extremely attractive feature in arbitration. Whereas in court procedures, you have perhaps different chapters in the White Book, which we're familiar with, that would apply to different types of litigation. In arbitral procedures, the parties are able to put their heads together and decide right when they get into the arbitration what sort of procedure they would like to adopt, bearing in mind the actual dispute that has arisen by then. And they work together, hopefully, together with the arbitrator or the arbitrating panel in arriving at the most suitable set of procedures to follow mutually. And that, again, is conducive to a sense of cooperation between the disputing parties. In technology cases, the flexibility in procedure has played a very strong role in ensuring that the dispute is resolved and adjudicated upon efficiently with the involvement of experts and the exchanging of reports and experts putting their heads together in coming up with an area of agreement, identifying only a minor or limited areas of dispute for more efficient adjudication. Next is the finality element, of course, because if the parties agree to finally resolve their dispute through arbitration, the grounds upon which they could hope to reverse the outcome of the arbitration would be very, very limited. And that ensures that the outcome of the arbitration procedure is final, rather than the parties having to wait for a number of layers of court rulings before they would finally know whether they have won the case or lost their case. Enforceability has been touched on, and that is often cited as a very attractive feature of international commercial arbitration, because then you can choose to enforce the award in any jurisdiction. Now, Hong Kong has an advantage because enforceability of our awards in China or our judgments in China has always been provided for in legislation. But that cannot be said of a lot of other jurisdictions. Next, I would like to examine whether commercial arbitration promotes access to justice. Now, some who are not familiar with arbitration would ask, why do we choose to pay for a tribunal out of our own pockets if there is a justice system, i.e. the judiciary, where you can get your dispute resolved by a judge who does not expect you to pay him? Now, that is, in fact, a question to be considered together with all the other features that support international arbitration as a preferred mode of dispute resolution. Although you don't pay for the judge, you nevertheless pay for teams of lawyers, and you risk appellate procedures, which could take much longer than you wish. And the cost of court proceedings are often not fully recoverable, even though a party may have won the battle from beginning to end. There is next the question of the struggle for equality of arms. In international arbitration, as Robert has already averted to, there is a much wider pool of talent because the legal team that participate in the commercial arbitration process does not need to be qualified lawyers or does not need to be lawyers qualified in a particular jurisdiction or in the Hong Kong jurisdiction. You have a much wider pool of talents who you can refer to and seek help from to conduct the arbitration on your behalf. Not even the tribunal, members of the tribunal are required to be of qualifications held in a particular jurisdiction. And sometimes that is necessary because international parties who are engaged in disputes may be parties who have nothing to do with Hong Kong, or maybe one of the parties could be a Chinese corporation. For example, recently I have an arbitration involving Russian parties and Chinese corporations, and the language that was adopted in the arbitration was English. And then we have a panel of arbitrators of diverse qualifications and origins. The lawyers who were handling the cases were Chinese lawyers with Russian lawyers backing up. So we have this diverse pool of talents that the parties can rely on in international arbitration. Whereas in court proceedings, the team of solicitors having conduct of the matter will always have to be lawyers qualified in the particular jurisdiction, and the advocates representing the parties will always have to be properly qualified in the Hong Kong jurisdiction, for example, and the same in any other jurisdiction, indeed, except for advocates who are admitted on an ad hoc basis, on a case-by-case basis, to that particular jurisdiction. There is a myth of cliques of arbitrators. It is concerned, it has been sort of rumored to be a concern amongst the litigation professionals that, in international arbitration, there would be suspicions of unfairness because international firms tend to get the big cases, and then they would be friendly with the arbitrators they appoint or did not appoint, or even the chair who they did not directly appoint, and arbitrators would want to please these big firms in order to get repeat appointments. Speaking as an arbitrator who has regularly sat in cases for the past 7-8 years, I do not find that to have any truth in it. Although I have seen arbitrators who tend to be sort of ostensibly polite or sort of more obliging to particular firms. That could be for other reasons. That could be because that particular firm has already a good understanding of the culture in arbitration and understands the limits of behavior or adoption of practices. For example, in a particular type of application, they wouldn't make submissions which are off the line and therefore are received with more favor from the tribunal. So it does not necessarily mean the tribunal would necessarily find in their favor just because a particular firm or a particular advocate is more reputable or famous or has more cases, as the case may be. There is this particular element that we should bear in mind, and that is, it is important for an international arbitrator to retain respect amongst his peers or her peers. And that element is a driving force to behave properly and to demonstrate fairness at all times. Next, what choices are offered, also on the point of what choices are offered in commercial arbitration that litigation does not offer? Well, we have consensual dispute resolution in international arbitrations. So parties have agreed in advance to resolve disputes in a particular manner, say arbitrations in Hong Kong IAC under Hong Kong IAC rules. And they can also agree to the formats and the procedure that will be tailor-made to suit their needs of the particular dispute or the particular type of contracts. The consensual nature of arbitration means that parties to commercial contracts will have put their minds to the nature of their agreements and how disputes are likely to arise. And parties, well, you can say that, well, but one party may have a stronger bargaining power. And for example, I hear that American companies in recent years, they do not necessarily want their disputes with any Chinese entities to be resolved in Hong Kong because they have suspicions or pretexts that Hong Kong may not be an independent jurisdiction anymore. Of course, there's absolutely no truth in that. And there is absolutely no evidence that is capable of supporting such a prejudice. However, parties will find themselves in their own bargaining positions and having different bargaining powers at the contract negotiation stage, and they can fight it out between themselves. There are also cascading dispute resolution clauses which make commercial arbitrations quite attractive, and that is the parties can agree in advance or in the middle of arbitration to go for mediation. And if mediation were not successful, they revert back to arbitration, subject to appropriate protection of the continued independence of the tribunal. The choice of arbitral institutions and which set of procedural rules to adopt, and rules of actual procedure within the arbitration, for example, document production and exchange, and the taking of evidence, and those are also attractive options that are available in international arbitration. Next point is that confidentiality is well protected, whether or not a court of law would objectively regard matters to be confidential and worth protection. In international arbitration, everything is confidential, and the parties are under mutual obligation not to disclose the nature of the dispute and any details within the arbitration. Looking to the future, we ask the question, is international arbitration developing towards the right direction, towards diversity or promoting better diversity? There are three aspects to it. The first I highlight is the mode of dispute resolution. Well, different rules are developed to suit the needs of different types of disputes. Rimsky has just highlighted some rules passed to help construction disputes towards a speedy resolution. And there are, of course, rules developed to deal with disputes on domain names efficiently and speedily. And these are all online procedures which seek to deal with smaller disputes more cheaply, more efficiently, without the actual attendance of the parties or their lawyers. I find that the most favored arbitral institutions tend to be progressive and responsive in updating their rules to suit the changing conditions and demands of the market. We're hoping to put together sports arbitration rules to set up a mechanism for sports disputes resolution. And we are also seeing an APEC ODR platform set up by EBRAM to resolve more cheaply disputes which are APEC in nature. Amendments to rules to quickly adopt to market environment is important to keep the arbitral scene alive and ahead of times. And arbitrators would be tasked to conduct the proceedings as cost efficiently as possible without compromising fairness, by including parties as much as possible in the design of the procedure most suited to the circumstances. The level of rigor of these rules would sometimes depend on how aggressive or cooperative the parties may be towards one another. And there is an increasingly strong tendency to ensure mediation is given a chance in the private dispute resolution process. Capacity building over the years have made available to the market mediation professionals, a strong body of them, of effective mediators seen to add value to the process. Right at the beginning of making mediation popular, we see that not a lot of professionals really know how to do it. So they were just sort of going through what they should go through generally, and they're not seen to add a lot of value. But after a few years down the line, we are seeing much more of a body of effective mediators to rely on. And that, in my view, adds significantly to access to justice. Diversity in format, I would quickly mention blockchain technology and ODR processes used currently in Hong Kong. The IBRAM APEC ODR platform is one of them. And we can see more of ODR, online dispute resolution platforms, emerging in the future. Now, I wouldn't go back to the point, which is very often rehashed, of the popular nature of online hearings now. It is now prevalent in international arbitration. 3-4 years ago, I would still be hearing arguments from counsel saying that we must not have a video conference hearing because it is against the agreement of the parties, but now no longer. Quickly, I would mention diversity in arbitral panel. Why is it important? A 2021 survey shows that 37% of respondents thought it does not matter at all. 56% thought it matters a great deal, the diversity in the constitution of the panel. And 36% thought that it matters. But where are we lacking in diversity? There are gender, racial, ethnic, geographical, cultural diversity, and diversity in training and background. Well, if we think about picking jurors, for example, it's not like picking jurors, because for commercial arbitration, there needs to be a certain degree of expertise. Otherwise, it's easy to get it wrong, in which case finality means that there's no way of overturning it, or very limited means of overturning it. So it is about a certain degree of expertise, and then on that basis, you try to build diversity. But it is not just about gender diversity. We have to understand what causes the lack of diversity and inclusiveness in the first place. And that could sometimes be the overvaluing of experienced or well-known arbitrators. And there is a deep sense of insecurity of choosing the wrong arbitrator and wanting to fall back on a safe choice. Next, there is asymmetry of information in the market on qualified arbitrators who are not well known. And there is a lack of transparency in awards informing professionals of the quality of a certain arbitrator. So all in all, I'm confident that in building capacity and making commercial arbitration more popular, there will be more information about arbitrators that would promote greater diversity amongst arbitration panel members. In 2021, Hong Kong IAC appointed 44 arbitrators, which was over 30% of all arbitrators appointed who were not appointed over the past 3 years. And that is a very commendable effort to make the arbitral panel more diverse. Now, who can make a difference? It is the parties, their in-house counsel, their counsel teams, arbitral institutions. And all of them will have to be aware of the of the positive qualities of a diverse arbitration panel. Diversity is free structure. Rimsky has mentioned funding of commercial arbitration and mediation. I would like to a little about outcome-related fee structure. As Rimsky has pointed out, the recent amendment bill seeks to provide some more flexibility in free agreements between parties involved in dispute resolution outside the system of public administration of justice. There is already, this outcome-related fees is already permitted in a number of major jurisdictions. China has been very comfortable with it. Our China counterparts, mainland counterparts, they are very comfortable with outcome-related fees. They've always had it in their litigation, arbitration. And in fact, to not have such an arrangement possible in a jurisdiction like Hong Kong will, no doubt, hamper the development of Hong Kong as an international commercial arbitration center. In my view, it is market-driven need which is likely unstoppable, and Hong Kong should rise to the challenge, lest it is left behind. It is somewhat disappointing to learn that recently when the Law Reform Committee went to LegCo to try to explain the bill, it was not very well received amongst the legal sector of our LegCo representatives. It could be a reason. It could be a result of a lack of familiarity or understanding of how it operates. But basically, the argument was that we don't know how to play the game. We don't like it. That was basically the message. That is very, very disappointing, because, well, legislators may owe their seats to people who elect them, but I think they owe it to Hong Kong to let us progress and develop as an international arbitration center. And I think the ORFS will be significant in that regard. So thank you very much.
I'm sure you'll join me to thank Winnie for the excellent presentation. I mean, all the topical issues that a lot of our participants have in mind have in fact been covered in Winnie's presentation. So we can tick off a few of the questions that have been submitted after your presentation. But given the limited time we have, without further ado, a number of questions have been submitted either online or by participants. So I will proceed to the Q&A session. And our panelists will forgive me for diving straight into some of the topics that a lot of our participants have in mind, because there's actually quite a bit of overlap in the questions that have been asked. Can I start off with this? It is one of the questions asked is promotion of the rule of law amongst the general public is one of the important initiatives of the government. Now, as arbitration proceedings are conducted in private, details as to how arbitration is conducted and the results are generally not available to the public. In your view, how should the arbitration industry participant attempt to promote the rule of law to the general public by participating in arbitration? Now, the chairman of the HAIC will forgive me for directing this at you first, but I'm sure you have been asked this question in the past. Rimsky.
Victor, thank you for the question. I think it's a very good question. Actually, it has been asked in this manner as well as in slightly different manner. Perhaps to begin with, confidentiality is, of course, one of the cornerstones of arbitration. But it doesn't mean that information about arbitration is totally lacking in the community. In some jurisdictions, some arbitral institutions publish digests of arbitral awards, just like cases. Of course, you won't find the names of the parties, you won't find the details which enable you to second-guess who are the parties in the disputes. But these are one way to deal with the situation. And since you asked me in my capacity as a co-chair, allow me to do this commercial. Actually, last year, the HKIAC put forward a new platform called the HKIAC Case Digest. It set out the past decisions by the HKIAC on decisions relating to the implementations of the rule as a summary, so that you know how the rules are being implemented. And in fact, we got the Well Arbitration Award for rolling out this HKIAC Case Digest. These are perhaps the more technical or logistical solutions. But another way of looking at the matter would be, I think it's for the arbitral community, particularly the practitioners, to go out and explain what exactly arbitration is. Because in some instance, in some jurisdictions, in some sector, this issue has been raised and quite seriously, if I may. And that is, they see a sense of secrecy behind arbitration, when in fact it is not. So I think the arbitration community has a duty to explain more to the outside world, not just the in-house counsel of big enterprise, but to the community generally, the rationale behind arbitration, as well as the benefits that can be brought about by both domestic and international arbitration. Thank you, Victor.
Yeah, thank you very much, Rimsky. Now, the questions keep firing in. I will continue. I've been asked to direct this at Robert. How do you think online dispute resolution may change the ecology of dispute resolution mechanism? I mean, do you envisage that face-to-face arbitration, mediation, or even litigation may gradually be replaced by online means? I mean, we all know the HKIAC has done a great job in moving disputes online. We have all done hybrid or hearings that are fully just on the internet. But what is the recent trend and what is your experience? And what do you think is going to happen?
Online hearings are, of course, very convenient. But I'm not convinced that it is going to replace face-to-face hearing, which has other advantages. For example, if you have a panel of arbitrators, they will be together. And when you are in the room with counsel for both parties and the parties, I think it's much easier for there to be interaction between them. Internet hearings are useful because often you have witnesses who are scattered around the world, and because of COVID, travel has not been easy. And of course, there are, even without COVID, there are witnesses who are not vital to the resolution of the dispute, but who are nevertheless important witnesses. And it could cut away time and expense if they don't have to go to the place where the arbitration is held physically. But on the whole, I believe face-to-face physical hearing is likely to continue, especially in the more substantial arbitrations.
Thank you very much. Now, and of course, over to Winnie now on the topic of diversity in arbitration panel. Now, the participants said that there's a tendency to nominate well-known arbitrators rather than spending time to make inquiries about someone that you have never worked with. Now, in your view, how can the Arbitration Institute assist lay client to pick the right arbitrator? What can be done? Do you think we can set up some sort of KPI for arbitrators, have more information on the objective information on how good or how bad they are? Any views on this?
I think arbitral institution play an important role in that, for example, in appointing a sole arbitrator or the president of the tribunal, the work of the appointments committee would involve shortlisting suitable candidates. And that, of course, will have to be a list, suitable in the sense of legal qualification, amount of experience commensurate with the size and nature of the case. And sometimes you also have to look towards what sort of co-arbitrators have been appointed. Now, in that regard, for example, if the parties have appointed very experienced arbitrators as co-arbitrators, then the arbitral institutions will find itself constrained to appoint a chair of commensurate experience, lest the chair would be lacking in authority. Now, if the parties would be prepared to research into suitably qualified arbitrators who are prepared to work hard, prove themselves, and at the same time will have the guidance of the chair, then that would be a different game. So, as I see it, all the council teams, the parties, and arbitral institutions all have to work together in order to ensure a thriving and ever increasing number of arbitrators in the pool in order to facilitate administration of justice in the international arbitration context.
Thank you very much, Winnie. Now, a question just came in about mediation, and I will direct this at Rimsky. The Chief Executive has announced to further promote the culture of mediation in the policy address. What is your view on how to encourage participation of mediation in different sectors, and which sector may benefit the most from utilizing mediation?
Thank you, Victor. I think mediation, if you look around the different jurisdictions in the world, whether common law jurisdictions or civil law jurisdictions, mediation has been used in many different sectors and different areas. In Hong Kong, I think so far the use of mediation has been primarily in civil disputes, for instance, matrimonials, and say small claims disputes. But I think there is room in Hong Kong to further enhance the use of different types of mediation. What we need is the mediation community should go out and promote mediation. At the same time, I think facilitation by the government would also assist, such as providing more course, more training to people who would be qualified in the different areas of mediations. For instance, I can give you one example. In some other jurisdictions, there are mediators in the schools, in the high schools, and the schemes turn out to be extremely successful, not only allowing seniors in the school to mediate disputes among the juniors, but it actually helps to promote the upbringing of the kids in the school. And another example I can give in terms of variety is that in Hong Kong or in many common law jurisdictions, mediation is not used in criminal related matters. But in some jurisdiction, in the less serious crime, mediation also has a role to play. So sky is the limit. It depends on how much resources we can get to further explore the use of mediation in the many different areas that we can have in the community. Thank you.
Thank you very much. Now, I won't be able to finish all the questions, but let me pick a couple that is more interesting and less discussed. Now, Robert, I'm sure you have heard arbitrations where the governing law is not Hong Kong law, English law, and you have lawyers making submission in front of you that are not qualified to practice in that particular jurisdiction. So you have English lawyer making submissions on continental European law, PRC lawyers making submissions on English laws. We have experience of that. Contrast how we do it in court. Foreign law is a matter of fact, of course. I think you've written a judgment on that. Which model do you prefer, and what is your experience in that regard?
Well, very often, if a matter of foreign law is involved, there will be expert evidence on foreign law. But when it comes to commercial law, I'm not sure that there is really that much difference between Hong Kong law and say Chinese law. The details may be different, but the thinking behind it is the same. And the approach to the legal problem is the same. So it's never been a problem so far as I can see it.
And Winnie, do you have some experience as advocate? I'm sure you have argued cases. I know you've at least argued cases based on PRC law, so you can share some of your insights on.
Yes, we do, and we always do it with lots of help. So even if an advocate is only an advocate conducting the advocacy is not qualified in the law of that jurisdiction, it doesn't mean that he does not have help in supporting his submissions. So I have frequently drafted all the sort of Hong Kong law submissions for another team of counsel from America or somewhere else for him or her to advance without me appearing in the arbitration. So it would be in their interest to have lots of help. So it doesn't mean that they would advance submissions that are necessarily incorrect. And in any way, all the submissions are well reasoned and backed with authorities, which the arbitral tribunal can duly assess. And often, if it is a case involving foreign law, there would often be at least one member of the tribunal who is familiar with the law of that jurisdiction. So in that sense, it also helps ensure that the arbitral tribunal gets it right.
Thank you very much. Now, we're running out of time. Finally, I have a question from a young lawyer who wants to go into arbitration. He said he's finding it difficult breaking into the market. He's not well known. Where are the opportunities? So I think all three of you, please chip in, because the person who asked the question sounds pretty desperate.
Wait, may I go first? Because I've often had to give this advice. So, well, I work very hard on the appointments committee to try to draw attention to younger qualified arbitrators. But I think the younger candidates have to help themselves as well. I think, first of all, you have to get the right qualifications, get the memberships of the institutions like the Chartered Arbitrators, Chartered Institute of Arbitrators, etc. And then you have to be seen in the circle, in the sense that you have to let people get to know you better as somebody who, say, have the opportunity to speak on a topic. And that you can do via whoever you practice with, either in a firm or in barristers' chambers. It is better for someone to have heard you or to have noticed your existence, for a start, to know your expertise, to know that you know a certain area of the law. And that would add to the attention paid on this person as a potential candidate. The arbitral institutions are, well, at least the HKIC is very good at it, always looking for potential candidates to appoint. And of course, once you break into the market, so to speak, for the first time, gradually there will be more cases. And the low-value cases are absolutely perfect for trying out new arbitrators. So it is not entirely hopeless, but you have to work very hard on it and not over-represent your own ability and experience.
Thank you. I think the young person also want to hear from Robert specifically, because in giving advice to young people, they're looking at the most senior practitioners here.
Well, I think if one is really interested in arbitration, one may wish to begin by acting as secretaries to arbitral tribunals. I think that is normally the best start. Otherwise, as a young lawyer, one should not expect to be appointed as an arbitrator too early in one's career, because you can look at the appointment of judges, say appointment of district court judges. There's a certain minimum years of practice before one becomes qualified. But the fact that the qualification will be set at 5 years or 7 years doesn't mean that a person who's done 5 or 7 years would be appointed. It takes time, because being an arbitrator is I think carries with it a very heavy responsibility. So I would suggest that they start by becoming secretaries to a tribunal. In order to do that, they have to, of course, make known their interest. And I think the best way to do it is to come to know some busy arbitrators, and hopefully they will become noticed and then eventually appointed.
Thank you very much. I believe our time is up. So on behalf of the panel, can I thank the Department of Justice again for organizing this conference and putting this panel together. And I'm sure all of you will join me in thanking our 3 distinguished speakers.
Thank you. Definitely also a big round of applause to our fantastic moderator, Mr. Dawes. Thank you so much. So now I would like to invite our moderator and our 3 distinguished speakers. Please remain seated and look at our official photographer right in front of you to capture this important moment. What an inspiring and also wonderful section we had just now. Once again, ladies and gentlemen, a big round of applause to Mr. Dawes, Justice Tang, Mr. Yun, and Ms. Tam. Thank you so much. Please be seated. Here wraps up our second panel section of today. And before we proceed to the third panel section, we will have a 15-minute break. So please enjoy the refreshments in room N204 to N210, which is opposite to this conference room. And also remember to return to this hall before the start of the third panel section. The starting time of our third panel section will be 3:45. So enjoy the refreshments, and for our online participants, please remember you don't need to log out from the system. So see you all in 50 minutes. Have a wonderful refreshment. Thank you.